conclusions, which is why we've asked you to produce those documents. I think this will be my final question. Were you also advised that based on the resolution of this impeachment court, wherein you were required to produce those documents, that there is also possibility of you being held in contempt?
Yes, we were also advised, Your Honor.
I just want to be sure that the witness is properly advised. And one last point on the criminal liability that you mentioned. Does that liability expose the witness as in his capacity as president, the officers, or what is your understanding of the law?
My understanding of the law is anyone who violates it, whether they be employees, bank president, or who discloses information with respect to foreign currency deposit units, violates such law, which is so stringent. No, it only allows, as an exception, as we understand the law, the express written consent of the depositor. No? And in this particular case, we do not have any such exception. We are confronted with this law. We understand the liability. And if I may add, Your Honor, we are confronted, and as I am confronted today, with those two possibilities. First,
Anyway,
one last question, Your Honor.
you did not bring the records.
no, Your Honor, we do not.
All right. Majority Floor Leader.
Mr. President, I have one last question.
Proceed.
I would just like to ask His Honor finally, did counsel also explain to you the provisions of the Constitution that the impeachment court has the sole authority to try impeachment cases?
Yes, the counsel did explain, and counsel did explain that, and we understood that there is this conflict between the law and the requirements of the impeachment court, and it will expose us to criminal liability, and that's the reason why we ask for guidance from the Supreme Court.
Thank you.
Your Honor.
Mr. President, Senator Svenya wishes to be recognized.
Senator Svenya.
Thank you, Mr. President. Just for clarification, may I address my questions to the prosecutor? We're a little bit confused. We counted 14 accounts that were subpoenaed from PS Bank. Do you have the list in front of you, Attorney?
Yes, Your Honor. The subpoena lists 10 accounts, Your Honor.
10. I have 14.
Not 14, Your Honor. Our request was 14, Your Honor.
Yes.
But the subpoena that came out only lists 10 accounts, Your Honor.
Thank you very much.
Your Honor.
The gentleman from Iloilo.
The witness, Your Honor, stated that he did not bring 5 accounts, which are all dollar accounts, because of his belief and his own interpretation of the law that is exposed to criminal liability. That matter, Your Honor, is a matter that they can pursue in the courts if they want. But insofar as this court is concerned, there is a subpoena for the witness to bring these accounts. There is no TRO issued. And even if there's a TRO issued, we reserve our judgment on that. But that's beside the point at this point. The important thing is the witness was required by this court to bring these documents. For his own reasons, valid or not, he said, no, I did not bring them. We therefore, Mr. President, move that this witness be required to explain in writing, not later than 12 noon tomorrow, why he should not be declared in contempt of this court. And to come back at 2 o'clock tomorrow afternoon with the documents.
The gentleman from Makati and Bicol.
Thank you, Mr. President. As I've told the prosecution before, I once sat in that prosecution table. In the impeachment complaint of President Estrada, we requested, and the Senate issued various subpoenas. Everyone complied on the peso account. When Citibank was subpoenaed, the representative of Citibank appeared, but said in a polite but firm manner that insofar as foreign currency accounts are concerned, they cannot produce it because of the foreign currency law, where there's absolute confidentiality. The Senate then did not impose a penalty on the Citibank representative. I do not know. I don't remember his name. But the records of that proceeding would show that. Now, I just want to show that in treating this, we should also be guided by precedents. There is a precedent in the trial of President Estrada. Are we going to disregard that precedent? I thought that practice any ruling made either by the Senate sitting as a Senate and the Senate sitting as an impeachment body will have to honor past precedents. Now, we have reached the point where there is now a proposition that the witness be explained why he should not be cited for contempt. I said we didn't go that far in 2001. The witness has explained that he is between the devil and the deep blue sea. Namely, the dilemma is, if he complies with the order of the Senate, he and the officers of the bank run the risk of being sued criminally. And that imprisonment could follow. On the other hand, there's the proposition here that the orders of the impeachment court must be followed. So the question now is, which one is the witness bound to follow? In a situation like this, we should grant to the witness some consideration. Consideration that he is saying that he is confronted with a dilemma. If that is so, are we so crude as to now say, you follow us regardless of what the consequences are for you, because that is our command? Have we reached that point? I'm asking the Senate, because I experienced already that one, that issue. If you dare disobey, we will cite you for contempt. The witness is now a victim of circumstances. He is not in bad faith. He is in good faith. He's faced with a problem. Which one is it to follow? The law on foreign currency deposits, which imposes a penalty of imprisonment, or the command of the Senate? I submit, Mr. President, because this is a problem which we should take, I think, with a little more circumspection and with a certain degree of prudence. Thank you.
Under the rules, there was a motion, and I take the statement of the gentleman from Iloilo in the nature of a motion to ask this witness to explain why he should not be cited for contempt or punished for contempt in not complying with the order of this court. Another member of this court, the gentleman from Makati, took an opposite position, which is, to me, a form of objection to the motion.
Mr. President.
Then, in that case,
Mr. President, may I offer a
majority floor
middle
leader,
May I offer a middle ground, Mr. President?
yes.
Let us cross the bridge when we get there. We can accept the motion of Senator Drilon that the witness be asked to explain until 12 noon tomorrow. Period. Let's decide later on,
Yeah, but,
based on his explanation, what to do, and not hover a sword of Damocles as manifested by Senator Arroyo. Well, if that could amend the motion of Senator Drilon, I hope so, Mr. President, and if he will accept.
But the tendency of the motion is actually to ask the witness to show cause why he should not be cited for contempt. There's an objection. And under the rules, we have to divide the House on this issue.
In fact, Your Honor,
Huh?
in fact, may I just make a manifestation?
Yes,
we
sir.
have not decided to cite the witness in contempt. For all we know, after he submits his written explanation, we will find it valid and sustain his position, and therefore, there is no contempt citation. But he must go on record, and he must be required to explain, as we discussed it earlier, why he should not be cited in contempt, and submit a written explanation, and we decide. For all we know, I would repeat, we may not even cite him in contempt when we find his explanation plausible and valid.
Precisely. If we find his explanation not plausible, not acceptable, then perforce we will be compelled to cite him for contempt. And there's an that is precisely the understanding of the chair, that there's an objection to that.
Yes, and that is precisely, Your Honor. Yes, the chair is correct, Your Honor, because this is a compulsory process. We must stand by our compulsory process. We have subpoenaed the witness. He has not complied with the subpoena. We want to know why he has not complied with the subpoena. And if we find his explanation valid, then so be it. It is valid. But if he does not, we do not find his explanation valid, then he is deemed in violation of the orders of this court, and we can cite him for contempt.
Then, but there is an objection to that
Yes, Your Honor.
motion, and so therefore, the chair cannot resolve
Yes, Your Honor.
that issue himself.
Yes,
It
Your
has to
Honor.
be resolved by the House, by the impeachment court as a
Yes,
matter.
Your Honor.
Yes.